Welcome to today's webinar on Brexit, what it means for EU citizens and their families in the short and long term, which will last approximately 1 hour, depending on the number of questions that you have. If you have any difficulties at all hearing the webinar and you're currently using your PC's microphone or speakers, you may wish to try the telephone option instead. If you select telephone in your webinar panel, a number and access codes will be shown for you to call in. That's on the right-hand side of your screen. As we have a high number of participants on this webinar, all audio lines will be muted to prevent background noise. We plan to record this session and make it available as a link afterwards, and for that reason we are keeping the questions anonymous. So if you want to put forward any questions that you have in the question section of the panel at any point, you can do that at any point during the webinar, and you can type those in again on the right hand side of the webinar. What we'll do is in the Q&A section towards the end, we will then deal with any of those questions at the end of our short presentation. I'm joined today by my partner Andreas White from our employment team and Gillian Brownlee, who's a senior associate in our immigration team. I'm Nick Rollason, and I'm head of the immigration team at Kingsley Napley. So I'm now going to take you just for a brief overview of where we are at the moment following the referendum outcome on Thursday last week. I'm sure you will have all followed it with huge interest, and the outcome announced early on Friday morning has had very profound impact in the UK already, both in terms of the impact on the economy, but also the political earthquake which it's caused. And I think really what we need to focus on today is how these changes may impact you in the short term now and in the longer term. And we're going to be focusing really on looking at the impact on your workforce. But what happens next? So, as you probably know, before the UK can start the process of leaving, and that is a process which may not be concluded, but which could happen in the longer term, the next stage would be for the UK to notify the European Council of its decision to withdraw, and that's a notification under Article 50, which starts the notification process and the negotiation phase before the UK would leave the EU. During that period, and when the notice is given, European Union citizens continue to have the right to live and work in the UK, and their status will not change overnight. There is nothing in any of the statements made by any of the politicians to date, other than one which I will refer to you in a minute, which indicate that there will be any sudden impact on EU citizens who are already living and working in the UK. The UK has a 2-year period from the date that we give notice under Article 50 to negotiate the terms under which it will leave. Again, whether we get to the moment when we issue the notice to the council, is quite a big if at the moment, bearing in mind the discussions we're seeing in the press at the moment about what is going to happen exactly now. But the main thing is to remember is that the UK will remain a full member of the EU. Free movement rules are going to continue while that is happening, and people will also be able to come to the UK and start working in the UK and bring their families with them in the normal way. There was some indication that the UK would apply more difficult rules for family members of EU citizens under the settlement which David Cameron agreed with the EU Council in February this year, but those rules only would come into play if the UK remained in the EU, and the outcome of the referendum was positive to remain. Because that hasn't happened, that settlement has fallen away, and therefore any of the proposed rules on restrictions on family members of EU citizens and some of the rules on restricting in-work benefits and child benefit, for example, have also fallen away. So those things won't actually kick in until and unless we leave the EU at the end of a long negotiating period. And remember this as well, and this is something which is very much in discussion today within the press, that the terms of the UK's leaving and the basis of its new relationship with the EU, which is also the subject of very considerable discussion, needs to be approved by Parliament, and Parliament would need to repeal the 1972 European Communities Act in order to actually affect this decision. But there may also be another referendum under which the government at the time that these negotiations are concluded, or almost concluded, may go back to the British public and ask for a referendum to agree the terms on which we're leaving and the future arrangements with the EU. So we have a long road ahead of us. You've seen the 2-year process. It may be much longer than that, and other EU member states may be happy to allow the UK longer to negotiate a settlement which works for both parties. And during that time, as long as we remain a member of the EU, the position of EU citizens will not change. Really what we're going to be talking about today is what you should be doing now to protect the rights of EU citizens working in the UK, and to ensure that they are able to continue living and working here. And we will also then go on to talk about what the future holds for employers looking to hire people from the EU, and how that will look in the future in a potentially a post-Brexit UK. So we'll move on to the questions now. We have 10 questions which we are hoping to go through this afternoon, and those cover really some questions from the employer's perspective more than the employees, but we will be looking throughout this on what EU employees should be doing. Most of the questions are to do with immigration, but we also have Andreas White here, who will be on hand to deal with some of the issues for employers thinking about hiring EU citizens, and so on. But I would encourage you to put forward any questions that you have. We've already had one question from a participant prior to the webinar starting. So the first question, what will happen while the UK is in this negotiation period? Well, as I've said previously, free movement rules continue to apply. So any EU citizens who are already working in the UK continue living here. There is nothing to indicate that there is any plan to change their status, and that has been made very clear by David Cameron. It's been made very clear by Boris Johnson, and those are probably the key players that will be looking at how this will happen in practice. So there is nothing to panic about at the moment, and really that's the message that we're sending out to employers: is don't panic. What will happen is the changes that come in will only take effect as and when the UK, and if the UK leaves the EU at some stage in the future. So up till then, we are okay. I should say one thing, and this is that approximately a week and a half ago, Chris Grayling, who is a cabinet minister and also a member of the Leave campaign, did indicate that they may have to, in part of their implementation plan for negotiating an exit from the EU, they might have to bring in restrictions on free movement earlier than the date of the actual exit. You'll see that that is a question under 6, and I'll talk about that a little bit more in detail about what the implications for that could be. But again, I would say 2 things on that just quickly, and that is that it's not going to happen soon, and that if it does happen, it will most likely be illegal, and it will be a question about whether or not the UK wants to comply with the law, or whether it wants to flout it and disregard it on its way out of the EU. So moving on to question 2, what should employers of EU nationals in the UK be doing now? Well, the answer to that question is nothing serious. There is no need to re-evaluate who your EU nationals are and what you need to be doing with them in terms of their ongoing employment. That will not be affected, or indeed your ability to hire EU nationals who are entering the labour market for the first time. The rules around them are the same, You can hire them without them requiring work permission. They simply need to have a legal working prevention check before they start work, and they're good to go. EU nationals don't need to apply for any form of documentation to show they're resident here at the moment, and we'll discuss whether or not they need to do anything on that. What we would say for employers is this, is a lot of their EU staff are feeling nervous, and understandably so. You may have seen there's lots of stories today in the press about some fairly nasty xenophobic behaviour in various parts of the UK against EU workers, and I think that will only add to that sense of uncertainty and concern. So what I think employers need to be doing is reassuring their EU staff, and I think just for that reason only, you may need to actually identify who your EU staff are, and focus some of the messages that you need to be pushing out to them just on that group within your businesses. The first thing that you need to do is communicate with them about what the impact is on them of the potential Brexit. So again, reassuring them. There's plenty of information out there, and I must say we've already sent out quite a few blogs and alerts to employers with some quite comprehensive advice about what their EU national employees should be doing at the moment in order to protect their status. So I think it's about communication and reassurance. Those are the key messages really that we're giving to our clients to make sure that their EU national employees are feeling reassured and don't need to panic. Another question, which moving on to question 3, we've had is, what do we need to do about British employees who are working abroad for them? So they may be working in an EU office, they may be sent there for a temporary posting, they may have been hired there, if they're British, they may have been hired there directly, or they may be doing a temporary assignment over there. Again, the answer in relation to that group is nothing needs to be done. EU free movement rules still apply. Whatever rules there are locally in the country they're in relation to applying for registration certificates as EU employees, or applying for any local registrations, things like that, which can be required sometimes of EU nationals, continue, but there is no need to do anything new or different. And just so that you know, and to reassure you, other EU countries will not take unilateral action against the UK or their British employees locally in relation to their ongoing rights to reside there and their rights of free movement. So as long as we continue to have rights of free movement for EU citizens, then we will not have an issue for our British citizens who are working abroad. This is also the position for those British citizens who have retired abroad and living abroad. We don't expect that they will be in any different position. We just had a question just to say, why is there still a question of if we leave the EU? And we thought that it would be a question of when. I think that is the big question actually of the moment. Will it be followed through? Is there the political will to follow it through in the UK? Bearing in mind that Parliament is generally pro-Remain, and Parliament, can ignore the advisory nature of a referendum. Remember, a referendum is not binding legally. It is simply an advisory notice to the government of the day to say we would like this to happen. And there are certain pundits and commentators who are saying that it is possible, although it may not be wise, but it is possible for a government to ignore the outcome of the referendum. So that is why we've said that if the UK leaves, because there are all sorts of obstacles along the way of actually getting out of the EU, and it may be that in 2 years' time, when we negotiate a settlement, that the mood has shifted and that people have seen the economic impact potentially of Brexit, and that they may decide actually they don't want this after all, and they may want to have certain things that can only be obtained by remaining members of the EU. Again, I can't say whether that will be the case, but that is why we put the word if in our discussion. So, you know, and there's some people who would like that to remain the case, the big if, and there's some people who would like us to plough on and get out of the EU as fast as possible. Amongst them, I think, some other EU member states who are quite keen for the uncertainty of the UK's leaving the EU to be resolved quickly. So, going back to the question in relation to EU employees, and this is the question that we've been asked most of all, is what is the status of existing EU employees both before and after the UK leaves? At the moment, as I said, they are in status quo, they can carry on working, they still have their rights of residence. But I think the important thing is that if the UK leaves, or when the UK leaves, depending on how you want to phrase it, they will have to be able to show that they have a particular status in the UK in order for that status to be protected. So as you may all know, EU citizens have the right of permanent residence after they've lived in the UK continuously for a period of 5 years. And in order to prove that they have permanent residence after 5 years, they normally have to apply to the Home Office to get confirmation of their permanent residence. And that can be any period where they've been lawfully working, lawfully residing here, whether it's as an employee, as a self-employed person, or as a self-sufficient person with medical insurance, any of those three, or a combination of those three. And if you can find 5 years where somebody is a qualified person within those 5 years and hasn't been away for more than 6 months in each one of those years, then they can generally apply and obtain permanent residence. So I think the first piece of advice for your EU employees is, if you qualify for permanent residence, you should apply for permanent residence to the Home Office. A couple of things that you need to know about that. It can take up to 6 months. You need to apply with a lot of supporting documents covering the entire 5 years. So for an employee, it would be all your P60s, all your bank statements, a letter from your employer or your various employers over that period, your P60s for any full year where you don't have pay slips for any full year where you don't have your P60s, and lots of other evidence showing that you've been living here, which could be things like utility bills, bank statements, council tax bills. So there are a lot of documents that the Home Office want, and they have to be originals. So if the employees have thrown all their documents away, that could be a problem. And the other thing is, in order to apply for permanent residence, you have to submit your original EU passport. And because of the large number of people who are now applying for permanent residence and have been for some time, it is likely that you can ask for your passport back during the application process, but it's likely that your passport will go up to the Home Office for about 6 to 8 weeks. So there are issues about people travelling while they're making the application. And for those individuals, what we are advising is that if they can get their national ID card, many people living in the UK don't have national ID cards from their own countries, but if they can obtain one of those, then it will mean that they can submit their ID card with the application and carry on travelling throughout the whole process. So it would certainly make it easier. So that's one piece of advice that we are pushing people to do, and we've currently got a few cases where we have people who simply can't give up passports for this 6 to 8 week period. So permanent residence is very important, and bear in mind 2 things. The Home Office don't ever write back to ask for documentation. So if you don't get the full documentation at the beginning, they can refuse the application. They won't write to you to ask you for anything else. So it's important to get everything right the first time. And the second issue is that if you have family members who are non-EU nationals, they should also apply with you, and they probably would be anyway. But it's important that you get those applications right, because if any of them are refused, particularly for non-EU family members, the Home Office can sometimes pass on their details to their external providers, who then start sending nasty letters saying you've been refused an application, you should leave the UK. Obviously that's completely incorrect and unlawful, but it is quite stressful. So I think getting the right documents is important, and making the application, and also having the ability to travel while the application is pending, if that's a requirement. The other group of employees are those who have been here for less than 5 years. So if somebody entered the UK 2 years ago, they're working for you, what should they do? Well, at present, there is no requirement for EU employees to apply for any kind of document from the Home Office. They can simply come and live here and be here for as long as they want to without needing a document. However, the issue for them will be this. If the UK leaves the EU in a couple of years' time, say 2 or 3 years' time, then if they simply want to change jobs, for example, or if you're looking at a new hire who's an EU citizen, you need to know that there's proof that they've been in the UK and that they are already resident here and they've already been accepted by the Home Office as exercising rights of free movement under the treaty. So what we would recommend for that group is that they apply for registration certificates. Those are quite easy to obtain. You can actually make the application in person at the Home Office in Croydon in the same way that you would if you were applying for, say, a Tier 2 extension or another same-day fast-track process. But one word of warning is that there are very few appointments for EU citizens. We've recently had a case where we simply could not get an appointment for an EU citizen needing to start work. It was a Croatian citizen, and they're in a slightly different position from most EU nationals. But if your employees want to get this done on a same-day basis, for example, because they don't want to give up their passports, they may have to wait several months actually to get an appointment at Croydon or at one of the PSC, at the Home Office's premium service centres. So the alternative is to send the application in by post, and generally you would provide, the employer would certify, and somebody just asked what that document is called. It's called a registration certificate, which is available for EU nationals, and you can apply for it on the EEA form, which relates to registration certificates. Sorry, I should go back a little bit to the permanent residence. If you're applying for EEA permanent residence after 5 years, you should use form EEA PR, P for Peter, R for Rollason, and that's the application. It's a very long application. I think it's 86 pages long, so it will take some time to go through it, it's quite a complex application to complete. We will be sending out these slides straight off this presentation as well, so don't worry, you'll get this information by email once this is completed. So just going back to that second group, those applying who've been here for less than 5 years, we're recommending they apply for a registration certificate because they have then proof that they're here, proof they're registered with the Home Office, proof the Home Office has accepted that they have a right to work, and that will help beyond Brexit. So if and when we leave, they will have evidence that they still have that status, and we hope that they will be able to continue working and living in the UK without any requirement to meet some new work permit requirements after Brexit. And they will also, it will be easier for them to change jobs because they will have this registration document which is valid for 5 years. So I think it's sensible for people to do that, to make those applications, but you have to be prepared for a long wait for those documents to come through because the Home Office is being overwhelmed and inundated by these sorts of applications, which are supposed to be dealt with within 6 months at the latest, but they can take longer. So I hope that deals with the two classes of EU citizens who are currently here and working for you. So one of the questions that we were talking internally is to do with hiring issues for EU citizens who are in the UK now or who are applying for jobs at UK companies, and really about whether there's any issues around employment law that you need to be thinking about. So I'm just going to hand over very briefly to Andreas, who's going to talk us through the kind of considerations that and questions that employers are having about whether they should take on EU nationals at the moment.
Thank you, Nick. Yes, the fact is that, as you already said, the law hasn't actually changed at all as a result of the vote last Thursday, and employment law today is exactly the same as it was this time last week. But obviously there is now a lot of uncertainty as to the rights of EU citizens moving forward. I think people, ought to already know, and I think most employers are well aware, that they couldn't have policies or practices in place discriminating against applicants on the basis of their nationality, their race, their ethnic origins. And so if, for example, you had an applicant from outside the EU who would require migration permission going forward, the right to work going forward, you shouldn't have treated that applicant any differently as things stood before. And the same point obviously now applies in relation to EU citizens. So if employers were thinking going forward, well, we ought not to accept applications from EU citizens because they may in the future be restrictions on their right to work here lawfully, then that is going to be unlawful, and it opens you up to discrimination claims. So as I said, I think that would apply to job offers that are already on the table that could now get reviewed as a result of what happened last Thursday. It would apply to hiring going forward. And it does seem to me that for the time being, from an employment law perspective, it is very much a case of business as usual and keep calm and carry on. Yeah, there is a trap there, which is if you were to make distinctions between applicants based on the fact that they may in the future need some form of permission because they're EU citizens, that would not be legitimate grounds to discriminate against them. Yeah, and would potentially cause difficulties.
Thanks. So just a quick question that we've had which is as follows: what about a non-UK resident EU citizen who's working in the UK? So somebody who lives in another EU member state but only works in the UK. And we have those situations of cross-border commuters, people who live in Paris or Amsterdam and come and work in the UK. Our position on those individuals is that they should, if they can, apply for a registration certificate. It may be difficult to do that if you're not resident in the UK and you don't have any proof of residence, and if you're living in a hotel from Monday to Thursday or Monday to Friday and then returning home, say, to Paris at the weekend. But it's certainly something that you should consider, because the problem is that if those people don't have any sort of permission to work or any resident status in the UK, then the protection of those who are already in the UK and have permanent residence stroke a registration certificate and a right to reside, there may be a distinction made between those people and people who are commuting in and resident somewhere else. So I think you need to think about whether or not that individual may be eligible for a registration certificate. They probably won't be eligible for permanent residence, although they might be. If they only spend the weekend outside the UK, they could still spend enough time here to qualify for permanent residence. And you may need to consider whether or not they can get a registration certificate. I think that would be wise, so that when and if the curtain does come down on EU nationals, they're not treated and prevented from coming in. I should also add that there may be some special rules around service provision or intra-company transfers which happen after Brexit as part of the UK's negotiation with the EU. And that is certainly something that, if we don't have full free movement rights, we certainly would want to push for having preferential access for service providers and those who are transferring and doing work between companies, between groups of companies. So I think that's obviously something that's further away than we can really look into that crystal ball at the moment. Another question, which is probably for Andreas, is: can you ask your current workforce to let you know who are EU nationals? Does asking such a question cause discrimination? Well, you could potentially send out a bulletin to all employees to say that this is what's happening with Brexit, and that if there are any EU nationals in the business who are concerned about this, they can, there is information which we're providing in terms of leaflets, information. We're also Kingsley Napley is also coming out to see clients if they want to, and doing drop-in clinics for EU citizens, which we'll be letting you know about a little bit more about in the next few days. But again, we would be happy for those people to be, asked that if they want to, they can come and attend that. But again, it may be sensible from an employer's perspective just to send that out to all employees, and not just try and target the EU citizens, so that they feel sort of a different group. So I think, and I don't know if Andreas wants to add anything to that.
No, I would agree with that. I think treating everyone the same is always a good starting point when you're dealing with any employment law HR-related issue. Certainly, advice is being given by some people in the employment law community to the effect that employers should carry out an audit to establish which of their current workforce are reliant on the UK's membership of the EU and free movement rights in order to work here. But I think the question actually raises a good point, and we do certainly know that quite a lot of migrant workers in this country are currently feeling very unsettled and quite unhappy about everything that's been happening. And I think a message of reassurance to the whole workforce and inviting them to come forward if they have any particular concerns is going to go down a lot better from an industrial relations perspective than a message saying, are there any EU migrants in the workforce? If there are, please let us know. Please get in touch with HR. We need to draw up a list of who you are, even though there might be actually legitimate reasons why employers may have felt they needed to do that. But we are saying that free movement rights continue to apply exactly as they did, and they ought to continue to do so for the immediate foreseeable future.
Thanks. We've had another question as well, just which I thought would be useful to answer. Does the registration certificate have a start date from now, or would this go back to when they first moved to the UK? The registration certificate is issued and starts from the date that it's issued by the Home Office. So if you applied now, you would get a registration certificate in, say, between 3 to 6 months, which would have a start date of whenever it was issued by the Home Office, and would give you a 5-year period of confirming that you have a right to reside in the UK. So we are recommending that people apply for them as soon as possible, because all they do is evidence that you're lawfully here, and that the Home Office have accepted that you have a right to reside under EU law based on the fact that you are currently working. Just picking up from one of the things that Andreas just said as well, in terms of looking at your workforce, you may have employees in the business who are currently in the UK not as EU nationals, but as family members of EU nationals. And their right to live in the UK is entirely dependent on their partner or husband or wife's right to reside in the UK. And I think it's important that that they are aware that it's important that their EU family members are doing the right thing, and if necessary applying for permanent residence and a registration certificate, as we've just mentioned, to ensure that they protect their own position, and therefore the family member's position is hopefully protected as well. But we would definitely then suggest that those individuals, they will already have residence cards, because they will be non-EU nationals who are dependent on their EU partners for their residence. But often in those situations, while the non-EU family member has a residence card, the main EU national and doesn't apply for a registration certificate, and that's very common. So it may be an idea for those individuals to go back to their partners and say, look, you should apply for a registration certificate, just so that you have proof of your own status and I don't get into difficulty. Having said that, the Home Office should have a record somewhere that their spouse or partner has already been exercising their treaty rights, because they would have made an application on that basis. But I think it's helpful to have that anyway, so that the EU national spouse partner can retain and maintain their status. So let's move on to question number 6, which is quite a big question, because this is the one that's driven everybody into a slight panic. So when Chris Grayling made his comments a week and a half ago about the UK possibly pulling up the drawbridge before the UK leaves the EU, and that would be to stop a mass influx of people before the door closes, what would be the impact? Would it be lawful, and could it be done? In short, the answer is it couldn't be done. If the UK wanted to do that and to try and stop a mass influx that it expected, it would need to opt out of the free movement provisions of the treaty, and it can only do so in cases where there are serious disturbances to its labour market and various other things. There are some break clauses in the treaty, but if it simply said, okay, as from today's date, we're closing off free movement because we suspect that lots of people want to come here because the UK is so attractive, then that would probably be illegal, and it probably couldn't be justified. And we would probably see that if that happened, there would be quite significant litigation against the UK government, and possibly very significant damages claims if, for example, an EU national had been offered a job in the UK, in the city, for example, was going to be paid, £5,000 a week, and was about to come, and then the door was slammed shut in their face. They would essentially, at that stage, probably have a claim for damages against the UK government for them not being able to start the work, which would basically run at £5,000 a week. So we expect that if the government took a rash decision like that, it would face a lot of legal challenges and a lot of damages claims, and it would be something that that I think would be very unhelpful, and would not put the UK in the best light, on the basis that the UK has always prided itself in the fact that it is a great observer of the rule of law. So it is possible the UK government could do this, and there could be some very difficult impacts for people about to come in, or people thinking of coming in, but we think it's unlikely, depending on the current political landscape. So what would happen if the UK leaves the EU? So we are talking about if and when, but assuming that there are negotiations, the UK has a plan on how to leave, it's put to Parliament, possibly to another referendum, and everybody's happy with it, then there will be a cut-off date when the UK will leave the EU. The position really we're concerned about is what will happen at that end date in relation to people who are already here. So those who have permanent residence will have their status, we believe, preserved and recognised on an ongoing basis. So that's the reason why it's important to get that status now or over the next few years when people start qualifying for it. So apply as soon as you meet that 5-year status. And the reason for that is that it is generally accepted under international law that if you acquire rights under a treaty, then those rights tend to be preserved if a party withdraws from that treaty. That's the general proposition. There's been some legal arguments between various academics, ourselves, and other people about what acquired rights will be protected, but we are pretty certain that permanent residence would be accepted. It may be that people who have permanent residence already might need to apply for a slightly different status than permanent residence if they haven't already applied for it before then, but to our mind it would be most helpful if people get their permanent residence confirmed by the time that we leave. For those who haven't yet got permanent residence, what's going to happen to them? Well, the UK, and I'll talk about this in the answer to question 8 about what new system might apply, but if people are already in the UK, have not yet got permanent residence, then we expect that those individuals, as long as they can prove they're already here, which is why the registration certificate is important, and you can differentiate them from new arrivals for people who've already been here, we don't think that those individuals will suddenly be asked overnight to comply with new rules on work permits. And that is for a simple reason that imagine you have an EU employee who's worked for your business for 3 years, they're part of the business, they're earning good money, and then suddenly you say, well, you need to meet a new work permit requirement under, say, Tier 2 General. We're going to put a resident labour market test on that approval, and if there's somebody in the UK who can do your job, then sorry mate, but you're out. I just simply cannot see that working. Firstly, because the huge number of EU nationals who will be in that position. At the moment, we estimate that there's about 1 million EU nationals who haven't acquired permanent residence who are living and working in the UK, give or take a few 100,000. The Home Office simply isn't built to deal with those numbers and those volumes of individuals. It struggles already dealing with 50,000 work permit applications a year. We can't really see that it would overnight ask people to comply with a new regime. So we think there will be transitional provisions which will allow those people to continue working in the UK, continue living here, and also to be able to change jobs. And the way that those transitional rules are set out, may depend on how long the people have been working. Just as an example, the UK has a treaty with Turkey, under which Turkish workers who are working in the EU have certain rights to be able to continue working in the UK if they've been working for a certain period of time. And it could be that similar provisions are put in. So, for example, a Turkish worker who's been working lawfully in the UK for 12 months can extend their residence and extend their permission, their right to work with the same employer. And once they've worked with the same employer for 3 years, they can then move to any employer they want to. That's an example of a sort of interim situation you may end up if we have transitional arrangements, which might then mean that there's a cut-off date under which, if you weren't in the UK working and building up some time, you might be excluded from these transitional provisions. I think it's unlikely, because if you move to the UK 9 months before the UK leaves, and you've accepted a job offer and an employer is employing you, I think again it would still be very difficult for the employer to then have to go through a tier 2 process and sack you if there was a suitable British candidate. I don't think the second reason I think that won't work is that it's very unfair. There's all sorts of other human rights issues about people who've been living here for some time, have maybe bought a property here, have their family here, have children in school here, and are earning money through their jobs, and that is the vexed question of human rights. Human rights protect quite a lot of things, but one of the things they protect is people's private life, where they've established a private life somewhere, and also their right to property, to peaceful enjoyment of their property, which could be income from employment, possibly their home, and so on. So there's all sorts of human rights reasons why the UK wouldn't want to suddenly impose a very difficult requirement on those individuals, because again, it could end up in ongoing litigation which could go on for years and years. And I think as part of the process of negotiating our way out of this, we will be making representations at various stages to the Home Office and the powers that be about the problems with having these transitional provisions that are unfair. So we've had another question. Do we expect any changes to non-EU citizens who are here on PR, given that we're hesitant to confirm EU citizens with PR would be okay? Just so you know, I'm not hesitant to confirm that EU citizens with PR would be okay. I'm fairly confident that they would have their rights protected. And so if, for example, the US partner of a Belgian citizen had acquired PR based on living in the UK with their partner stroke spouse for 5 years, that status again would be protected. And it's probably likely that if they had already acquired PR, subject to them not having restrictions on having dual nationality, that they could possibly also obtain British citizenship, which would certainly give them absolute protection. We haven't talked about British citizenship yet, and one of the questions which we had at the beginning of the session was in relation to eligibility for British citizenship. I think it's important that if people are eligible to apply for British citizenship, which would generally be 5 years and then they obtain permanent residence plus another 1 year, that they should apply for it if it won't affect their current nationality, i.e. there's a restriction on dual nationality, and that it won't affect their tax status. Again, these are things that people might want to think about when they're applying for citizenship. But we are saying to people who are eligible, if there's no problem with dual nationality, then generally we would say go for it, apply for it for you, for your children, and remember that children who are born in the UK and whose parents subsequently obtain permanent residence have an entitlement to obtain British citizenship if they're under 18, so they can register as British citizens. And children who are born in the UK when their parents have permanent residence are also automatically British. So, there are various rules which help children to obtain citizenship, and that may be something that employees would want to explore with their own families about what's the best status to have, which doesn't affect their own home status or their own home nationality. So, what would the new system, that we're on question 8 now, what could the new system which applies to EU nationals after Brexit look like? There's been a lot of discussion recently, and this is something that Michael Gove put out in April this year, about what on the immigration side the UK would like, or the Leave Party would like. I think there are a number of problems with having an Australian points-based system, and that is this. The Australian points-based system has two aspects to it. It has a sponsored aspect which is very similar to our own Tier 2 system, so there will be no difference really. In Australia there is a temporary visa which is called a 457, which is sponsored by an employer, and then there's a permanent sponsored visa which individuals can obtain a long-term permanent residency, which is more like a Tier 2 general. So those routes exist, but they are not points-based. They have nothing to do with people's age, qualifications, previous work experience. They're simply driven by the employer sponsoring the individual, and in some cases showing that they are they're training Australian nationals, and in some cases showing that there's no labour market impact, that they've tested the labour market and so on. So there is a system now that is very similar to the UK system, where Australia is different is that it has a skills stream, which generally is, there are a number of these skills streams, but generally there are other types of non-sponsored visas where individuals can apply via the Skills Select program and just make an application showing what's called an expression of interest and say, I'd like to come and live in Australia because I'm very skilled, please approve me. And that can go down a number of different streams. You can do it independently, you can do it sponsored by or nominated by a particular province or region, and that is tested on a points-based criteria. So would that apply in the UK? We don't think so, and the reason we don't think so is that the UK had a similar type of visa, the Tier 1 General, which replaced the Highly Skilled Migrant Programme, and as you will all know, to our great sadness, that program was closed in 2010 by the Conservative government working in the coalition on the basis that they did not want individuals coming into the UK without a job offer, without a sponsor, and simply arriving in the UK and competing with locals to look for jobs in the UK market, even if they are very highly skilled. So the UK has made it clear, certainly the Conservative Party has made it clear, that it doesn't want that type of visa. So I think my own view is that it's unlikely that we would get a similar points-based system where there is no sponsor, because it would undermine that idea that the system should be driven by demand by UK employers rather than by demand by the individual who has the skills who wants to come to the UK. So I'm not convinced that the points-based system is something that would be palatable in the UK in the current environment, and I don't think that those who've suggested it as an option have really understood what it means and why it wouldn't work. So those are my views. We may have some more discussions on it, but our view is we'd be quite happy with a points-based system similar to Tier 1 General without a sponsor, because it does provide a solution in many cases, and it is quite helpful. So we could end up with a system that's more helpful, not just for EU nationals, but for everybody, if we go down that route. So that could be one of the very small benefits for employers in the UK, which you'd need to have to weigh against the loss of the ability to hire EU nationals. I think, from speaking to most employers, I think the loss of the ability to hire EU nationals would be a much greater loss than the gain of having a small number of points-based system migrants coming in from both the EU and the rest of the world. So again, watch this space on what happens. But the important thing is to note is that the current Tier 2 system, if that were applied to EU citizens from the date that we leave, would only really cover the top end of the market. It would cover, degree level qualifications at NVQ level 6. So what would happen to people coming in skilled, semi-skilled, lower skilled roles that don't meet Tier 2 criteria in terms of occupation and skill level? Well, as you probably all know, there would need to possibly be some changes to Tier 2 to then look at some of the occupations that might be in shortage, which are not NQF6. And we're talking there probably about technical roles, plumbers and technical roles like that you may find suddenly there's a massive shortage of. I don't want to focus on plumbers too much because I know it's a bit of a cliche, but it's exactly those types of roles that you might really struggle, particularly in the construction industry, to fill from the UK labour market. So then there may be a review of Tier 2 and there may be a review of the skills level and possibly the shortage occupation, where industry is saying, we used to fill these roles with EU citizens, we can't do any more, there's a shortage, let's put this on the shortage list. And then Tier 3 is the other big category. So you may remember that Tier 3 was brought into the points-based system when it was launched, and Tier 3 was initially a tier for lower skilled workers, and it was initially envisaged that would be a tier that you could use for people coming in to do seasonal agricultural work, to work in hospitality and construction. But it was never used because, thankfully, we had a large number of migrants who were available coming in from the EU. So Tier 2 has remained dormant all the way through. But what will happen, I think, if there is Brexit, is that Tier 3 will have to be opened because, farmers, for example, people in the construction industry, people in the hospitality, catering, restaurant industries will really struggle to find the employees, the workers they need. So Tier 3 will need to be opened. It may be subject to quotas. We may have a quota for Tier 3 each year based on demand and maybe farmers and the users of Tier 3 pitching for their requests every year, and there being a quota based on that. But who knows? But we certainly think that if there is a Brexit, that Tier 3 will need to be activated, and there's no way around that. It will be open because generally the immigration system does not discriminate on the grounds of nationality. It will be open to anyone who can apply to come in. So it won't just be EU citizens, it could be citizens of Ukraine, of Belarus, of China, of wherever. And that brings with it all sorts of complications around applying for visas for these individuals. If it's short-term work, making sure they leave, and there'll be a huge compliance regime around Tier 3, which currently a lot of employers don't face because they're not sponsors and they don't need to sponsor people because they're using EU nationals. So that will be a very significant change in the lower skilled sector, where people who have never been sponsors, employers will suddenly have to become sponsors and deal with a whole range of complicated compliance regimes, have people dedicated to doing this, have compliance consultants, lawyers and so on helping them. And I'm sure that all of you listening into this know the headaches that Tier 2 compliance as a Tier 2 sponsor can bring about, and that will simply be extended to a much broader group of people with all the expenses and costs and time that involves. So, and the cost is really the biggest issue that we are looking at the moment. If you look at question 9, our penultimate question for today, the cost is a very serious consideration. If you imagine that all these EU nationals that you've been employing quite freely, those who are already here will be fine, but if you are continuing to hire EU nationals into the future, they would most likely fall under some sort of a work permit system. That will be subject to government processing fees, visa fees, also because we won't be tied into the European social security system anymore. It will also be subject to IHS, the NHS surcharge fees, and that will be for each one of those EU nationals that you employ. So in terms of a strategic consideration, I think that employers need to think very carefully about their budgets beyond Brexit, because they will suddenly have a very significant cohort of employees who need to be sponsored. There will be huge costs around that, and as you know, the Home Office and the government are keen to make the immigration system self-funded, so funded through visa fees, and those visa fees will keep going up and up. So I think cost is the biggest strategic consideration when employers are looking at what will happen in the post-Brexit world. Also, the flexibility of being able to hire people quickly. If the same rules apply for employers hiring EU nationals out of UK universities, again, the same rules that apply for Tier 4 to Tier 2 switches will be applicable. We're not expecting anything particular there. There might be some youth mobility schemes which are set up specifically with the EU, because I'm sure that the UK government will want its young people to be able to go and work in the EU, and whether it's picking grapes or working, working on various parts of the EU doing different jobs, they'll probably want to have something reciprocal with the EU for youth mobility, so we may be able to benefit from those types of visas. But I think the key message is this will become much more expensive. And if you think about, one of the figures I think I saw was that 28% of employees in the city are EU nationals. That's a very significant cost, per employer, to have to then, look at maybe paying for a 5-year work visa for an EU national £5,000 or more in some cases, when you factor in all the visa costs, the IHS costs, and also potentially the skills charge that's going to come in next year, which will again significantly increase all of those things. So it will be a very significant change and a very expensive one. The last question really is, what will the longer term immigration and employment ramifications be? Well, I think we've talked about the immigration ones as far as we can, as far ahead as we can see, if and when we leave the EU. I think maybe from an employment law perspective, Andreas is just going to make a few remarks about what we might see, and looking at what provisions might go in a post-Brexit world.
I think actually, Nick, we're coming up to the end of our 1-hour slot, and also it does seem to me that although it's interesting from an employment law perspective, from an HR perspective, to speculate about the degree of deregulation that could follow Brexit, the simple truth is that at this stage it's just far too early to say. So although that there is speculation as to changes being made in relation to agency worker rights, collective consultation, rules in relation to remuneration in the financial sector, and various other things, working time changes, in relation to holiday pay claims, that sort of thing. It's all possible, but I think at this very early stage, it's just far too early to say, and really no one can say with any degree of certainty now what the terms of the divorce from the EU and the future deal will be, and it will ultimately depend on that. And I think it's interesting listening to what you said about the costs on the immigration side. I think it may be said it may have been said in the Leave camp that, of course, whilst there will be costs, there will be great savings to be made from being free of EU red tape and deregulation. But I have to say I'm quite doubtful at the moment that ultimately, if we do get to the end of this whole process and we do leave, that it will free up employers to such a dramatic extent on the employment law front that it offsets the complications and costs and red tape that would appear to be consequences on the immigration side.
Yeah, I think just as a closing remark, I agree with all of that, and I think that we will just see a huge cultural change, which is that we've been used to dealing with EU citizens working in our workplaces freely on the same basis as British citizens for a very long time, and that that change of taking them out of that for new people coming in will be very significant cultural change within employers, which will be difficult to take, and it will involve a huge amount of red tape, additional red tape, which you've all been familiar with non-EU nationals and the Tier 2 system, and it will simply mean that gets expanded and increased to a whole bunch of other people. So I think on that rather negative note, we'd like to close off this webinar. We hope that you've enjoyed it and that it's answered some of your questions. We will be circulating the slides to all those participants. I think that was one of the questions. There will also be a recording of the webinar, and all those who put questions, those questions will be anonymous, and we haven't mentioned them, so it will just be an audio recording. And we'll circulate that if you want to pass that around your teams for those who weren't able to attend. And just in terms of other things that we're doing at the moment with our employers, we are also coming out to see employers who would like it to have drop-in clinics for EU citizens who have questions about their status. So if you want to find out about that, please get in touch with the individual that looks after you at Kingsley Napley and ask them if it's possible for us to come to you. We're also running a series of seminars which will be dealing with ongoing questions throughout the next 6 months anyway, at all of our seminars, where we'll have a Brexit session as part of that to see where we are and what we know. And we'll keep you updated as to any changes that are coming up. But we hope things will calm down and that everybody will be able to get on with their jobs without too much uncertainty in the future. So thank you and good afternoon.